This is us.
Well, not really. This is just a fish.
But this is our point of view.
Right. Today we are going to observe two Supreme Court cases that took place in the 1960s and 70s.
But these aren't the real cases. These are just crudely made reenactments made out of modeling clay. But for all of our intents and purposes, we can pretend that these are the real cases in order to see how and why these cases happened and what their outcomes were.
Shh! The first court is now in session.
It was 1959, and 5 parents of several children who attended the new Hyde Park School District filed a complaint about having to recite the prayer, "Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country," each morning.
Our children's right for religious freedom is being violated. They shouldn't be reciting any kind of prayer in the morning at public school.
The school did not actually require that the students recite this prayer.
The prayer is completely voluntary, and it helps to encourage stronger moral values in the classroom.
But the alternatives made students choose between either singling themselves out from everyone else or going along with something they didn't believe in. Parents felt as though this blatantly favored some religions over others.
Although there is only one judge shown here, there were 8 working on this case. The ruling was 7-1 favoring Engel and the idea that public schools cannot instigate a prayer. This court will not condone any religion being taught in any public school unless it is taught in such a way that is objective.
That means that they have to teach it for its educational value, and not just because they feel that it is important as a religion. Also, in order to teach any one religion, they must teach all major religions equally. This case set the stage for other court decisions relating to the separation of church and state in the next few years.
Our second case took place from late 1971 to early 1973. It all started with a woman named Jane Roe. "I don't see why I can't get an abortion. It is my choice after all, right?"
But Texas and Georgia state laws denied her this right.
That would be taking the life of a baby, not yourself. Therefore, it is not your right.
And so she took it to court. "It is unconstitutional to deny her this right. Therefore, I must rule that she will be allowed to have this pregnancy aborted. However, we are dealing with a life here, so there must be a compromise." As the case turned out, a woman would be allowed to have an abortion at any time within the first 3 months of the pregnancy. The state could not intervene during this time period.
During the next 3 months, the state could only intervene in order to protect the woman's health.
And during the last 3 months, once the fetus had a conceivable chance of surviving outside of the mother's body, the state could intervene at any time in order to protect the baby.
This case effectively brought an end to all abortion court cases.
And that is how these 2 particular cases went, with, of course, our own artistic license attached. Please note no fish were harmed in the making of this video. Also note that in reality fish do not serve on any jury.